7:33 right now. Time to answer some of your legal questions and return to Fox 26 senior legal analyst Chris Tritico. Good morning, Chris. Good to see you again.
Good morning, Jose. It's really good to have you back.
Now, we're going to begin with Javier, who writes, we purchased our house from the previous owners less than 2 years ago. In that time, we have had 4 busted pipes. The house is about 8 to 9 years old. Our insurance company had the pipe inspected and determined that it was defective. Our insurance company is currently subrogating against the manufacturer for my deductible and the amount they paid for the restoration and mitigation company. Is there anything I can do to protect myself against the more than likely additional pipe bursts in the future? Is there a 10-year window or responsibility the builder of the home, the manufacturer of the pipe, or the plumbing company has? Can I file a lawsuit to have them pay for the repiping of my house?
Well, yes, is the answer. It's not a 10-year statute of limitations in Texas. It's a 2 or a 4-year statute of limitations, depending on what you file. Now, this is not going to be against the builder necessarily, but it gets the piping company. You put in your email, this was PEX pipe, and I researched that, and there is a class action lawsuit against the manufacturer of PEX pipe because of its defective piping, or the allegation is it's defective piping, and it's busting all over the country. So here's what I want you to do. I want you to do 2 things. I want you to investigate whether or not the owner, well, the owner obviously didn't tell you about this when you bought the house. He had a duty to warn you about the busting pipes. Surely he knew, and he didn't tell you. So that's one thing I want you to look into. Second is I want you to investigate filing a lawsuit against the PEX pipe manufacturer. Do not join the class action. Seek out the attorney of your choice in the Houston area who is litigating PEX pipe cases, and talk to that lawyer or those lawyers who are filing those cases, and hire one to file an individual case for you in a mass tort case, not a class action. Class actions do not benefit the class, they benefit the lawyer who filed the class. So hire the lawyer of your choice and get on this quick before your statute of limitations expires. Good luck.
Our next question comes from E, who writes, my husband and I have lived in our apartment for 3 years. We noticed random fees added to our account without notice. We received an extra charge for renter's insurance despite showing proof that we have a contract with the company they suggested. The agent stated we have to pay the fee or more will accumulate. In February, a fee of $60 was added for a pet fee the agent said was missed. We pay our pet deposit and monthly fee of $15. In April, another fee was added, but she couldn't explain what it was for. We asked to speak to another agent or a manager, but she claims to be the only one who can address any issues. What can we do about this? We still have a year to go.
So if she won't talk to you about what the fees are, go over her head. And if she won't tell you who her boss is, find out the name of the management company who's managing these apartments, or who the owner is of the apartments, and just call them directly. And ask for who it is you need to talk to about this issue, or write them a certified letter and tell them in writing what's going on, and tell them you need to get some resolution of this issue. Just go over her head. If that doesn't resolve the problem, you might have to seek out the lawyer of your choice to write them a letter. But I would ride this lease out and get out of there at the end of this lease, regardless of whether or not you get this resolved now. Check your lease, see what it says about fees and what fees they can add to your lease, and ensure that you are paying the proper amount of fees. Add up what you're paying extra so that you may need to file a suit later to get those fees back. Good luck.
Our next question comes from Mark, who writes, my siblings and I inherited our parents' primary residence when they died and the will was probated. 2 of us have been living there before and since her death. Another lives elsewhere in their primary residence. We cannot seem to reach agreement regarding disposition of the equally shared property we inherited. Is there a way to force a court-ordered disposition of our shared property?
There is. It's called a suit to partition property. And that's what you're going to have to do, is partition the property. Now, at the end of the day, when you do that on a partition, if you can't resolve it by way of who's going to own the property and who's not, the court's going to force a sale of the property. That's the way you partition it. Generally, if you can't resolve who's going to own it and who's going to buy it. But that's the name of the suit, a suit to partition the property. My suggestion is that you contact the Houston Bar Association and see if they can help you set up a pre-suit mediation. And if the three of you can get together on a pre-suit mediation and mediate this issue and see if you can, through mediation, partition get a partition agreement together and then decide how you're going to partition the property this way, much cheaper than filing lawsuits. Good luck.
Chris, great answers. Now, we want to let our viewers know that if they want to send you some legal questions, they can just go to our website, fox26houston.com. You can find Chris's segments under the Morning News tab. And as always, for any specific information and advice, you really should contact an attorney of your choice. Again, thank you, Chris.